The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. Before we begin, I want to extend a warm welcome and thank you to our colleague, Judge Jasmine Yoon from the Western District of Virginia, who has graciously agreed to take time off from her very busy other day job to join us this morning. Thank you so much for being with us. We have 4 cases on the docket this morning. First up is 24-6027, Landholt versus Corley. And we have one attorney appearing remote, Mr. Lindeman, and Mr. Trullock. I hope I'm saying that correctly whenever you're ready. Trullock, go ahead.
Your Honors, may it please the Court. My name is Chris Trullock. I'm on behalf of the appellant, Timothy Landholt. This case begins under the jurisdiction of the Richland County Clerk of Court, Family Court. Mr. Landholt was under their jurisdiction pursuant to child support order. In March 13th of 2014, bench warrant was issued for his seizure for failure to appear upon a rule to show cause for child support payments. The record would indicate that he was unaware of this. That's not particularly relevant, but in any event, sometime between March 24th of 2014 until June of 25th, 2014, I'll come back around to this, the date is uncertain, the Clerk of Court received a bench warrant from Judge Jones requiring that he be seized and brought before the court to answer for his failure to appear at the child support hearing. The Clerk of Court between March 24th and June 25th of 2014 transmitted a duplicate warrant on their own accord and without any instruction from the judge to the Richland County Sheriff's Department, supposedly for the purposes of seizing Mr. Landholt in the event they find him. On March 28th, 2014, my client, Mr. Landholt, voluntarily appeared at the Richland County Family Court to make a child support payment. He was unaware there was a bench warrant for his arrest. Again, that's not particularly relevant. This is background for the court. He was seized then and there in the courtroom and brought before Judge Morris. This is a different judge than who issued the bench warrant, but again, this is just for context so the court understands that this was the duty judge at the time. He was brought in front of the duty judge, and Judge Morris heard him out, decided that she would restructure his payments, required that he pay $200, and that he, quote, be released from court that day. I, quote, be released from court that day, Your Honor, because the appellant takes a position that that was at least, if not earlier, the last moment that the court really had anything to do with the bench warrant. Now, from that moment he was released, again, it's uncertain whether or not the Clerk of Court transmitted the duplicate warrant, a copy of the original bench warrant for his arrest, from March 24th, just before his seizure, until June 25th of 2014, many months after, to the Richland County Sheriff's Department, that duplicate remained with the Richland County Sheriff's Department after he had been seized with the initial bench warrant for his seizure. That bench warrant remained.
So, Mr. Trullock, I appreciate the recitation of these background facts, but I don't know, we're certainly not here to adjudicate whether or not the clerk did something wrong, right? The question is whether or not there's immunity for whatever missteps the particular state official might have committed. So I think we need to get to that.
Yes, Your Honor. So, Your Honor, ultimately the testimony from the Deputy Clerk of Court, Mrs. Janet Irvine, who's the number 2 and was deposed as a 30B6 witness for the Clerk of Court's office, the governmental entity also known as Ms. Jeanette McBride in her official capacity, testified that it was the clerk's responsibility to issue or transmit these bench warrants to the Sheriff's Department for seizure, and that it was a, quote, mandatory process for them to recall these bench warrants if they had been served, as in this instance, where he was served in the courthouse, but yet a copy of this duplicate bench warrant was with the Richland County Sheriff's Department for 4.5 years before he was seized again on the same exact bench warrant in 2019 in August. They testified that it was a mandatory process that they handled this, and that there was a failure of any documentation in the file to show that they had recalled this bench warrant, which should have been in there, and the normal business purpose. And if I haven't already said this, Your Honor, again, Mrs. Irvine confirmed that this was the clerk's responsibility. Otherwise, the record, Your Honor, has no information to indicate that Judge Morris or Judge Jones had any idea.
So if I understand, your position is that because this was a mandatory duty that did not lend itself to any discretion, that the South Carolina's State Immunity Act shouldn't apply in this context?
That's correct, Your Honor. I would take it a step further and say that at the summary judgment stage, that the defendant, who had the affirmative burden of resolving all genuine issues of fact, did not meet that burden as well. But yes, Your Honor, ultimately that the law was incorrectly applied and ignored South Carolina precedent.
So before we get to that issue, so why are we as a federal court, obviously, I don't know, there's no question about our jurisdiction, I guess, but why should we decide that question in the first instance rather than having, for example, South Carolina's highest court do that via certification?
Your Honor, I suppose that that would be an appropriate mechanism for this court, but I would submit that since the case law appears very clear on this matter, that this court could decide the issue.
There is no case law. I mean, what do you mean it's clear? Tell me why you think it's clear.
Your Honor, respectfully, I would cite to the Proctor v. Department of Health, which is cited in the opposition to the motion for summary judgment and, of course, the opposition to the recommendation. The Proctor Court, Your Honor, I think made it unequivocally clear that the analysis of whether or not a governmental entity receives qualified or quasi-judicial immunity is whether or not they were acting in a discretionary capacity, in which case they should receive it, or if the act was one that was required that they did not complete, in which case they should not receive it.
Is that court interpreting the state immunity statute?
Yes, Your Honor.
Go ahead.
Not only was it interpreting sections, well, actually all of them, Your Honor, but the only relevant ones, Your Honor, for today, Your Honor, sections 1 and 2, which talk about judicial immunity and quasi-judicial immunity and administrative action and inaction of a quasi-judicial nature. The Proctor case evaluated that, and they cited the Hawkins case, Hawkins v. City of Greenville, and in that they clearly stated that the real question is whether or not the act, not the actor, the act was one that was mandatory, whether it required was a ministerial duty for this individual. If the act was discretionary, then they might be able to receive the immunity of quasi-judicial immunity if the then defendant, now appellee, could establish that beyond a genuine issue.
And who was the actor in Proctor?
The actor in Proctor, Your Honor, was the city. Oh well, in Proctor it was the. Your Honor, I forget the name of the agency. It was the agency responsible of controlling. I think it's Department of Health, Your Honor. It was in control.
And was that a case that was brought to the district court's attention or analyzed in any way by the district court?
It was brought to the district court's attention. Proctor was brought to the district court's attention, Your Honor, yes. The district court seemed to read the appellant's citation to Long v. Seabrook, which is also cited by many of the cases in Proctor. But right underneath that block quote to Long v. Seabrook was the block quote to Proctor, which unequivocally said that the analysis of whether or not these individuals received qualified immunity is whether or not it was ministerial or discretionary.
But if you look at the statute itself, I see that under Section 5, there's a word discretion in there. So I'm talking about the South Carolina Tort Claims Act. It says the exercise of discretion or judgment by the government entity, and it goes. But we're looking at Sections 1 and 2, and I don't see the word mandatory or discretionary there. So don't you think that the legislators would have made it clear by either saying non-discretionary or mandatory when drafting the Sections 1 and 2 of the statute?
I do not in this case, Your Honor. And that is because Proctor made clear that the codification of Sections 1 and 2 was a codification of the McCall case, which the Supreme Court issued abolishing sovereign immunity, and that Proctor said that those two sections that the appellee relies on, and presumably including the discretionary section, were a codification of the 1985 case of McCall before the Tort Claims Act was enacted in 1986. They said this is what the legislature codified. They codified the McCall case. And so the McCall case said that, and they basically said they were taking it verbatim, that the meaning of the terms of qualified immunity were not about the actor, who they were. It was about the act, and it applied to ministerial duty. So, yes, Your Honor, if you read the South Carolina Tort Claims Act without the context of the McCall case, I understand how there could be confusion there. But the McCall case, and especially the Proctor case, clears that up and says, no, do not confuse quasi-judicial immunity with the role of the actor. Analyze the act of the actor. And the act, as this court has said in Maryland v. McCrae, is quasi-judicial immunity is not a formal association with the judge, but an exercise of discretion like a judge. And that was basically the exact same determination of the McCall case and the Proctor case in 2006 and the Proctor case citing Hawkins versus City of Greenville in 2004. So, Your Honor, I respectfully submit, I understand how without understanding what that language really means, quasi-judicial, could lead to an interpretation that the court below made, especially in relying on DeSoto, Your Honor, which is in direct conflict with the Proctor case. And if you look to the dissent in DeSoto, the dissent really clears that up and actually points to the United States Supreme Court and clarifies that, where the United States Supreme Court stated in Anton v. Byers and Anderson that other than judges, quasi-judicial immunity is functionally comparable to discretionary judgment. Because the point is that judges have extreme discretion, but that protection from liability ends at the end of discretion, when it becomes administrative, when it becomes ministerial. And they impose that same responsibility on actors under the government as they would, although to a much less favorable degree for non-judges, where they state that you have to analyze whether or not the act was ministerial or mandatory. If it was ministerial or mandatory, in other words, not discretionary, then they are not entitled to the quasi-judicial protections that the court below, in this case, afforded.
Why can't the state, I'm sorry,
I didn't have a question.
why can't the state statute, section 2 of that statute that talks about administrative action of a judicial or quasi-judicial nature encompass the sort of ministerial action that occurred in this case?
Your Honor, I would say because of that qualification of a quasi-judicial nature, and also because Proctor is explaining, and the Hawkins case that it cites actually doesn't deal with just Section 1. It deals with Section 1, 2, 3, 4, 5, and 13, I recall, Your Honor. They read those two sections as one and the same, and the administrative inaction qualified of a quasi-judicial nature is what changes it and makes sure that the protection is only when it's in a quasi-judicial nature, which again, the United States Supreme Court and Proctor for the South Carolina courts has said quasi-judicial immunity is really a determination of whether or not it's discretionary or ministerial. So the court, again, Your Honor, is pointing to the fact that...
So how do you define administrative then? What's administrative to your mind under the statute?
To my mind, Your Honor.
Well, unless you wrote the statute, maybe not, but tell me what you think that the legislators intended.
My reading of the Proctor case, Your Honor, which is tantamount to a treatise on these issues, when they talk about Fail and Clark and all these other cases, is that administrative, without that qualifying language, administrative of a quasi-judicial nature, administrative is ministerial, Your Honor. That's how I read that. In other words, it's not a discretionary task. It's one that must be done in the course of that governmental entity's responsibilities, Your Honor.
Do you have any South Carolina Supreme Court case that stands for the fact that administrative action includes quasi-judicial, or the what you just said is the mandatory action?
I beg the court's indulgence. There is a citation, I believe it's in the Proctor case, that says that even judges aren't protected from administrative tasks. And that's how I came to that conclusion, because I struggle with that as well, is that, what is the difference between the statute, which says administrative action or inaction of a quasi-judicial nature, which is very important, versus an administrative task. I believe it's in Proctor, Your Honor. There is a specific quote, though, and I don't want to take up the court's time with me looking for this, but that they say that even judges are not protected from liability in administrative tasks. I do not have that cited for me, Your Honor. I know that it's cited in either the Proctor case or potentially the Maryland v. McCrae case, but I believe it's Proctor, Your Honor. And so that is where I interpret the Proctor case to have that delineation, is that an administrative task itself is ministerial unless it's of a quasi-judicial nature, which means that it is discretionary.
Well, South Carolina has followed the common law for historically, And in common law, that non-discretionary actions don't receive immunity, correct?
That's correct, Your Honor.
Right.
Yeah.
So and in the statute, if South Carolina meant to do away with that, it would seem like they would have done that clearly in the statute, but they didn't.
Yes, Your Honor. I would say that they would have to put language in there that was rejecting the McCall decision from 1985, saying we're going to restore total immunity to the government, and they didn't do that, Your Honor. The Proctor case, they specifically.
Exactly. They knew McCall was out there. If they were doing that, abrogating that, they would have said, no, we're doing it the common law. That non-discretionary matters are also receiving it. And in this case, it's not a matter of deciding whether it's administrative. The question is it discretionary or non-discretionary? And I think it's beyond peradventure to say that this clearly was just non-discretionary, right?
I agree.
The warrant should have been full. It wasn't. I mean, so whether you call it administrative, whatever, it seems like South Carolina has never said that. And then you got the pilot case and other cases as well. Filey, I guess you pronounce it, that still exists. But go ahead.
Well, I agree entirely, Your Honor. I also look to the dissent in DeSoto, which was heavily relied on by the court below. In fact, all they relied on, it appeared, was the DeSoto, Mississippi case, again, which is outside of South Carolina jurisdiction and contradicts South Carolina, and reading of the South Carolina Code. I found that a very unusual combination, and of course I objected to the use of DeSoto against South Carolina precedent. But Your Honor, if you look to the dissent, in my opinion, gets it right. In fact, they point out to the Mississippi Supreme Court that the national review, including the United States Supreme Court, stops liability at the edges of discretion and where it meets ministerial duty. And they even go so far, and this is of some issue in the case, Your Honor, they even go so far as to correct the Supreme Court, although they're in the dissent, so it's not a binding correction, that the judge did not have the responsibility in the DeSoto case to recall the bench warrant. Much like in this case, Judge Morris and Judge Jones actually had no idea, as far as the record is concerned, what was going on with the bench warrant once they signed it and said he should be seized, including the duplication and including leaving it with Richland County Sheriff's Department for 4.5 years.
Mr. Trulick, before you sit down, because you are over your time, I have one, and my colleagues may have some other questions, but this case involved two claims, right? Below one, a 1983 claim that was dismissed, and then we're left with the state law claim. Do you think it was an abuse of discretion for the district court to exercise supplemental jurisdiction over the state law claim once the federal claim dropped out of the analysis?
I do not believe it was, Your Honor. I believe my recollection allows the court to retain jurisdiction in some instances if there's been a considerable amount of activity before the court. At this time, I don't have a reason to believe they abused discretion. But again, Your Honor, the 1983 claim ultimately wasn't resolved until Judge Leiden, the trial court judge, accepted the recommendation. So it would have been a very narrow corridor of keeping jurisdiction, Your Honor. I would respectfully submit that if this case is remanded, that it would be a good question for the court whether or not they retain jurisdiction if you were to side with the appellant. I would agree with that, Your Honor.
All right. Thank you very much.
I'll turn it over to my opposing counsel.
Mr. Lindeman, I hope you're feeling better.
Thank you, Your Honor. May it please the court, and I appreciate the court's accommodation for me being able to appear remotely. Your Honors, I represent the appellees in this case, Kendall Corley and Jeanette McBride, as the clerk of court for Richland County, South Carolina. As the court just recognized, from a procedural posture, the federal 1983 claim was dismissed at summary judgment, and as a result of that, there was no appeal. So the only claim that's remaining before this court is a state law negligence claim. The appellant defined the appellees as including Kendall Corley, but I would submit to the court that Mr. Corley is no longer a party on appeal because he was solely a party for the 1983 claim. The state claims were withdrawn as to him. So the correct appellee is Jeanette McBride as the clerk of court. The lower court granted summary judgment on the negligence claim based on one of several different grounds for summary judgment that we raised. There were additional sustaining grounds, obviously, that this court can address if it wishes, based on the record, based on the statute of limitations running, as well as based on private analog immunity under the South Carolina Tort Claims Act. But the district court found that it was simply necessary to address one ground, and that was sovereign immunity under the Tort Claims Act, specifically under subsections 1 and 2 of 15-78-60. And that's obviously the focus of this appeal. Your Honors, I would submit to the court that the plain and ordinary language, particularly of subsection 2, is explicitly applicable to the factual pattern in this case. The plaintiff alleges that the clerk of court, through her employees, failed to recall or cancel a bench warrant after that warrant was served. There's some questions as to, and I'll get to those, as to who actually had the duty, whether there is a duty recognized under South Carolina law for the clerk of court. But ultimately, in determining the immunity provision, it's not necessary to address those issues. I would submit to you that subsection 2 in particular is very clear. It talks about administrative action or inaction of a judicial nature. That's much broader, actually, than judicial immunity is from the common law. And obviously, the state of South Carolina, when it adopted the Tort Claims Act, it reenacted sovereign immunity completely as a result of the decision in McCall v. Batson, and then waived it in certain specific aspects with certain limitations, such as caps on monetary liability. But the provision...
Under Section 2, what would you say constitutes a quasi-judicial administrative action? Is recalling a bench warrant a act of judicial nature or quasi-judicial nature under the Act?
I would think that it would be my position that canceling or revoking a bench warrant is something that's judicial in nature. Quasi-judicial is, in terms of a non-judicial proceeding. It's considered in the law and fairly well established in the nature of an administrative or executive type of adjudicatory process, something along the lines of a planning commission, a board of zoning appeals. Quasi-judicial is not encompassed within judicial, but it deals with similar adjudicatory functions, but not by a court, but rather by an administrative or executive agency. Part of the confusion in this case, and before I get to that, let me point out to the court a very important point. When the South Carolina General Assembly enacted the Tort Claims Act, they intended it to be comprehensive and to limit the liability of the state and its political subdivisions.
Are you quoting from legislative history, or this is your opining on it?
I'm about to quote from the legislative history, Your Honor.
Oh, the history of it.
And the legislative history in this case has actually been codified in section 1578-20. And I would call the court's attention to subsection F of that statute. It says the provisions of this chapter establishing limitations on and exemptions to the liability of the state, its political subdivisions, and employees must be liberally construed in favor of limiting the liability of the state. And that's what I was getting to, Judge Gregory, that the General Assembly specifically codified a rule of statutory construction within the Tort Claims Act, advising the courts that the provisions of the Tort Claims Act should be liberally construed in favor of limiting the liability of the state and its political subdivisions. And that would be very applicable to the extent
I don't think that's a question. The liberal part is the first question to ask you, what is it judicial or quasi? When it comes to what is quasi-judicial, we should be liberal in terms of anybody perhaps who supports the court or judges, like this case here. then that's the liberal part, but the question is whether or not they abrogated the long-standing common law clear rule that non-discretionary acts don't get immunity. So that's not, that what you just read does not resolve that. It seemed to me Section 2 just makes sure that you don't have to be a judge to get immunity. It includes now administrative action, quasi-nature. It also extends there, but it didn't say that they changed the hard and fast rule, as counsel said, even for a judge. You know, it's not automatic and non-discretionary. That still is the case there, and they clearly could have abrogated that, but they didn't.
Well, I would respectfully disagree, Your Honor. They did abrogate that because.
The common law, just because it extends to administrative simply means, yes, they are in the gambit of potentially to get it, because they do things that are discretionary. And to that extent, then they would get it. Beforehand, it was a question whether or not quasi-judicial actions could even get discretionary immunity. But now we know they can. But non-discretionary continues to be, as under the common law, it is not immunity for it. And they clearly could have said it if it otherwise would have been.
Well, Your Honor, I think part of the problem here and part of the issue with the appellant's argument is the term quasi-judicial has two definitive meanings in the law. One, it's as I explained it earlier.
You don't understand what I'm saying is that what you read was exactly right. South Carolina said, be liberal in terms of what is quasi-nature and when it's the administrative action. But it didn't say it's going to extend it to non-discretionary.
Well, Your Honor, again, the Tort Claims Act provides a specific section, and this is a point that Judge Yu made. Subsection 5 deals with discretionary acts. And I recognize there's some confusion because quasi-judicial has multiple meanings in the law. One is, as I described it earlier, it describes adjudicatory proceedings by quasi-judicial bodies, such as a planning commission or a board of zoning appeals. As used in some of the case law that the appellant relies on, it's a synonym for discretionary. If you look at the Proctor case and the Wilson case and the Long v. Seabrook case, all of those cases, which incidentally none of which deal with judicial acts or any type of acts of an adjudicatory body. The Proctor case is a case involving the Department of Health. The site in that case is to the Hawkins v. Greenville County case, which is a stormwater flooding case involving the adequacy of stormwater facilities in Greenville County. Have absolutely no bearing, no similarity to the issues in this case. But in those cases, the term quasi-judicial was used as a synonym of discretionary to basically say something is either ministerial or is discretionary. The case law also talks about ministerial versus quasi-judicial. But that is not the use of the term quasi-judicial in subsection 2. That's clear from the fact that they're referring to legislative, judicial, and quasi-judicial acts. Those are all obviously dealing with other branches of government and specifically adjudicatory bodies. In this case, I would submit, as the district court found, that this falls squarely within administrative action or inaction. The case law that deals with ministerial versus discretionary or ministerial versus quasi-judicial have no bearing whatsoever on this case.
Mr. Lindeman, I'm sorry to interrupt. If we take your view of the matter, and you can correct me if I'm wrong about this, but you seem to be suggesting that there's a two-tiered structure with respect to immunity under the Act and who gets it or who doesn't. It seems like you're suggesting that if we're talking about judicial or quasi-judicial acts, that the immunity is broader than if we're talking about other officials who are doing acts which might or might not require the exercise of discretion, that somehow that is different and not entitled to as much immunity. The Proctor case is an example of that. You pointed out that that involved the Department of Environment and Health, and the court there, discussed the issue of immunity in the context of sections 1 and 2. And I get it that we're not talking about a court official, but I guess the question is, if we took your view, we'd have 2 tiers of immunity. Is that what you're saying?
No, I'm not suggesting that at all. I'm suggesting that
So are you suggesting
discretion.
so I'm sorry, before you get to your answer, so do you think the Proctor court got it wrong?
I think the Proctor court was focusing on discretionary immunity, which is pursuant to Section 5. And our appellate courts in South Carolina have been very clear how you can prove discretionary immunity in South Carolina requires a showing of making choices, and then ultimately those choices having some sort of professional background or standards behind it. That's not what subsection 1 and 2 are. In fact, if you're going to read subsections 1 and 2 as providing only for discretionary immunity, it makes subsection 5 meaningless. And obviously you don't interpret statutes in order to make a provision meaningless. The purpose of subsections 1 and 2 were to provide judicial, quasi-judicial, prosecutorial immunities. That's the way they've been interpreted. In this particular case, a clerk of court is entitled to judicial immunity, even for their ministerial acts. And that brings me to the next question, which is there hasn't even been a showing in this case that this is a ministerial act. The plaintiff simply says it's so, but there's absolutely no law to suggest that that's correct. There is no statute that governs the cancellation or recall of any arrest warrants. There's no statute that sets forth what the duties of the clerk of court are relevant to arrest warrants, the handling of arrest warrants. There's absolutely no authority that the appellant has cited to this court that would suggest that this was a ministerial, or as he calls it, mandatory duty. I'm not sure what a mandatory duty is. The law distinguishes ministerial versus discretionary. And what I would point out to the
Mr.
court...
Lindeman, let me, I'm sorry to interrupt again, but maybe not, maybe because it's so clear, right? If the judge makes a decision to recall a bench warrant, I can't imagine that a clerk would have any authority to somehow countermand that decision. It's the judge who has made the call, the discretionary call, whether or not to recall a warrant. And once that happens, it's up to the clerk to implement that decision. So where's the discretion in that? It seems entirely ministerial, even if the statute doesn't say so expressly.
Well, the record doesn't show that the family court judge ordered the warrant to be recalled. Ultimately, the warrant was actually served on that particular day, on March 28, 2014, by a sheriff's deputy. And quite frankly, part of our position in the lower court is that it was the sheriff that had the responsibility then to actually not serve the duplicate warrant, because the sheriff already knew that that warrant had been served. His own deputy had served the warrant on the 28th. So it is very much questionable as to who has what role. It's not established by statute. It's not established by policy. It's not established by regulation. This is not where the family court judge instructed the clerk of court to take a certain action from the bench. And in fact, that's part of the appellant's argument.
And whose burden is it to show that you have immunity? Whose burden is it to show that you have immunity?
Right.
Not right. That's not right. That's a question. Whose burden is it? Yeah.
The burden, it falls on the defendant for an immunity defense.
Your clients.
That's right.
Right. And you're saying there's no evidence to show that. You're the one that had to put forth, you have the burden.
Well,
Normally,
there's
people
no-
have a
there-
right to come to courts to address their grievances. It's only when there's a shield as such. And you have the burden to show that the shield is present and formidable.
That's right, Your Honor, and based on the documents in the record, the available documents, there's nothing that indicates that the family court judge gave any direction to the clerk of court to recall or cancel.
That's the merits of the case, but as the Chief Judge Diaz said to you, as I said, the judge, it should have been recalled, right? I'm sure I'm exaggerating, but I propose there's a bend, like, oh, this is a recall by the judge. This goes into the area where it's no longer active so that no one will serve it. It's not like, well, let me see, should I recall this one or not? I don't know. This one is, you have to do
Well,
it.
again, as the question is about this whole idea of a recall or cancel, the warrant itself was served, so it's technically not going to be canceled. It was in effect and it was served. I go back to my point that I believe that the responsibility falls upon the sheriff. The sheriff actually served the warrant, or his deputy served the warrant. Therefore, they should have known that the warrant had been served, and there would be no need to, quote, recall or cancel the warrant. Quite frankly, you don't typically cancel a warrant that has already been served. But the bottom line is, as I was getting to, there's no evidence that this even qualifies as a ministerial duty under South Carolina law. I would point out to the court one of the cases the appellant cited, 2008 case from the Supreme Court of Wilson v. Preston. The South Carolina Supreme Court defined a ministerial duty as, it says, the duty is ministerial if it is defined by law with such precision as to leave nothing to the exercise of discretion. In this particular case, I would submit to you that a duty has not been defined by law with such precision. In fact, can't point to any statute, as I mentioned, can't point to any regulation. Even we put into evidence the sections.
So your defense is in demur. Your defense is in demur rather than immunity. That's what you just said. It's not even.
No, my defense is, number one, this isn't a ministerial act, and number two, it falls within the scope of subsections 1 and 2, primarily 2, because it qualifies as administrative action or inaction of a judicial nature. It is not ministerial, and even if it was, there was no exception under the Tort Claims Act for ministerial acts. If the General Assembly intended that exception to be there, it would have written it in. It did not do so. And then I raised 15-7820F, stating the public policy or the legislative findings that to the extent there is any question as to the meaning of the statute, it should be construed in favor of limiting the liability of the state. Again, this whole situation with the Proctor case and the Hawkins case has no applicability here. This case does not involve a quasi-judicial act where it's defined as discretionary. The intent of subsection 2 was to talk about legislative, judicial, and quasi-judicial in the sense of an adjudicatory body, as I indicate. And you don't even need to get to the quasi-judicial, because this is an administrative inaction of a judicial nature. As the district court said, that falls squarely under the immunity provision. Ultimately, Your Honor, we would ask the court to affirm the decision of the lower court to the extent this court believes that the statute is difficult to interpret. I know Judge Diaz raised the possibility of certification. That would certainly be an avenue for the court to be able to ferret out the proper interpretation of subsection 1 and 2 in this context. I don't think that's necessary, but certainly that remains as a possibility. Thank you very much, Your Honors.
Thank you, Mr. Lindeman. Mr. Trulick?
Thank you, Your Honors. Your Honor, I must have been talking too fast in my first 15 minutes. Most of what I have to say left is really just response to Mr. Lindeman. He noted that the recall was judiciary, Your Honor. The facts, as established by the 30B6 witness, that it's not even, in my mind, even a question, but at the very least, a genuine issue of fact whether or not it was judicial, because The judge had nothing to do with the way that the clerks handled the warrant after it was issued. The clerks are the ones who decided to duplicate it. The clerks are the ones who testified that they were responsible for the management of the bench warrant after it was issued, and they were the ones that testified they were responsible for recalling them after they had been served. Your Honor, the Judicial Act was carried out, it was finished, it was done with Judge Jones once he was seized and brought before the court. After that, it was the clerk's responsibility to deal with the aftermath of that, and it wasn't pursuant to court order. The judge didn't say, I need you to gather all the duplicate warrants that you have out there, and you're shielded by my authorization. The judge had no idea what the clerk's doing, at least according to the record, or if they did, it was a nuanced understanding. And if we look to the fail case even says mere knowledge of what the governmental entity is doing by the judge does not convert it into a judicial, quasi-judicial act. So, Your Honor, I respectfully disagree with my opposing counsel. The recall was strictly incumbent on the clerk's office. This was not a duty of the court. In fact, once he was seized and brought before the court, that was the end of the initial bench warrant, and the duplicate was a consequence of the clerk's own office in duplicating it and sending it to the Richland County Sheriff's Department. Your Honor, Mr. Lindeman also says that Proctor was really talking about Section 5 and discretionary immunity. Proctor is an extremely comprehensive, almost treatise-like case that covers the application of the immunities from Section 1 all the way through Section 5 and beyond. It took the time to comment on this case, clearly to resolve any conclusion. It was not just about Section 5. It was about explaining that Sections 1 and 2 embraced the similar concepts of discretionary decision-making.
But you concede that it wasn't, I mean, it didn't cover this particular set of facts involving what we consider to be a judicial function with respect to warrants. It was an executive function, right?
Yes, Your Honor, I agree that the Proctor case was not asking the question about whether or not clerks carrying out this duty was the problem. I agree with that, Your Honor. But I think that's the reason the case goes into such great detail, hitting on all these cases, so they can guide the court in the future and say, look, it's not about the role, it is about the act. And they put great focus on that, Your Honor. My opposing counsel also says that this reading would make discretionary immunity meaningless. Section 5 would make it meaningless. I don't agree, Your Honor. There are other entities out there that have no real association, to a judge, whether he's next door or whether something the judge did created a necessary consequence for them to resolve. There are tons of agencies out there. Certainly, we have the Department of Social Services in Jensen and the Department of Juvenile Justice in Vail do involve judges. But of course, we look at the Clark case where we have troopers out on the road and whether or not they're exercising their discretion and going too fast and chasing after suspects. Well, discretionary immunity became a relevant issue in that case because it was whether or not they were reckless in what they were doing. So discretionary immunity is not rendered worthless. It's just that in this case, the reading with McCall as applied to these facts says it is not about who we're talking about, it's about what they are doing. And Your Honor, with regard to ministerial versus mandatory, it was this court in McCrae, Your Honor, and I beg the court's indulgence, that stated that, quote, no more protection than any other state ministerial functionary who fails to discharge a mandatory duty. So this court has recognized that ministerial and mandatory are synonymous terms, and I don't think I need to quote that case for this court to understand at least that argument. Mr. Lindeman also discussed duties. This issue is not, I would respectfully submit, it's not for this court on whether or not there's a duty. We're here talking about the judicial immunity. But to the extent this court deems that that's a relevant issue, Your Honor, South Carolina courts also, and I'm sure other courts as well, recognize that if you assume a duty, you are expected to act reasonably within that duty. And the clerk of court's office assumed the duty of handling these bench warrants, or recalling these bench warrants when they've been served. The testimony from Ms. Irvine was exactly that we have to deal with this. It is a mandatory process for us to deal with this. The duty comes from the assumption of the responsibility. But again, Your Honor, I respectfully submit that duty is not an issue before this court. And finally, Your Honor, in summation, if I hadn't said it before, I do respectfully ask that the court consider the appellant arguments with regard to analyzing these facts under a ministerial duty analysis. I do ask that you reverse the trial court below, and if more is necessary, I would ask that you reverse and with instructions to consider the facts under a ministerial duty analysis. I have nothing further, Your Honors, but I am more than happy to answer any questions with the remaining time I have left.
Thank you very much.
Thank you,
Mr.
Your Honor.
Turlock. Appreciate the arguments. Both counsel will come down and greet Mr. Trulick, and Mr. Lindeman will greet you virtually, I guess, since you're not here. I'm glad that you're feeling better, and come down and greet counsel and move on to our second case.
Thank you, Your Honor.
One 5-7, Wheeling Power Company versus, Wheeling Power Company Mitchell Plant versus Local 492 Utility Workers Union of America. Ms. Smith and Ms. Dahl, whenever, or Mr. Dahl, whenever you all are ready.
Thank you, Your Honors. May it please the Court. My name is Amy Smith, and I'm here this morning on behalf of Wheeling Power Company Mitchell Plant. There are two questions on appeal this morning. The first is whether the district court should have dismissed this action under the complete arbitration rule that this court established in Peabody Holding. The answer to that question is no. The second question is whether the arbitrator exceeded his authority under the collective bargaining agreement in this case. The answer to that question is yes. Your Honor, the answer to both questions is really controlled by Article 3, subsection B of the collective bargaining agreement. That's the rights of management clause. And Article 3B provides the company shall have the right to assign or contract work to persons or organizations not represented by the union. This right is limited only to the extent that it shall not be exercised when such action directly results in the layoff or discharge of any employee covered by the agreement. And it further provides that in the event of arbitration over the company's exercise of the rights set forth herein, the sole question for the arbitrator shall be whether the company has violated the foregoing limitation. Your Honor, Peabody Holding, which established the complete arbitration rule, made it clear that the scope of the arbitration is controlled by the collective bargaining agreement. In this case, the sole question under Article 3B was whether the company violated the arbitration provision, and specifically whether anyone was discharged or laid off by virtue of the company invoking Article 3B. The arbitrator answered that question in the negative. That is, the arbitrator found that no one was discharged or laid off when the company invoked Article 3B, and that concluded the arbitrator's sole question and sole authority under the collective bargaining to proceed with the arbitration. When the arbitrator continued and said that it would next consider a remedy, that was outside the scope of the arbitration. The complete arbitration rule was satisfied when the arbitrator made the determination early in his award that, in fact, no one had been laid off or discharged.
But if the arbitrator reserved his right to revisit, if the parties couldn't agree on a remedy, it sounds like the arbitration is not complete.
Your Honor, that is correct that the arbitrator purported to reserve his ability to fashion a remedy if the parties could not agree. However, the arbitration provision in the CBA did not give the arbitrator the authority to fashion a remedy. This is a case where the sole question was whether anyone was laid off or discharged. That's very clear.
Is that the case, even though it seems like the union didn't rely on Article 3B, they were relying on Article 2. So how does that impact your answer?
Well, Your Honor, Article 2 is the union recognition clause of the provision. That's a general clause that applies to determine who is recognized by the union. However, even the arbitrator recognized in his decision that if there is a specific clause that applies, that controls over the general clause. And from the beginning, the company has been invoking Article 3B and the Management Rights Clause. And I refer you to page 261 of the Joint Appendix, the arbitrator's decision, where he recognized that even if the Article 2 applied, which is not at issue here, but the company believes it does not apply, that in fact they're not part of the bargaining unit. But even if it did, that it's the specific clause that controls under these circumstances. So,
Can I ask you a question about you mentioned the scope of the arbitration agreement, and you highlighted, I think quite correctly, the third sentence that purports to limit the arbitrator's authority to decide whether or not workers were laid off, and if not, that should be the end of the analysis. That's your position. So is that, as I understand it?
yes, Your Honor.
Is that, that third sentence, are we talking about arbitrability in the classic sense, and is that a question for the arbitrator or for the court? And if so, the district court didn't really grapple with that issue, so why wouldn't we send it back to the district court to decide the meaning of that clause? Or is it so clear that we need not do that?
Your Honor, it's very clear in this instance that the arbitrator exceeded the scope of the arbitration agreement when he went beyond that third sentence.
Well,
and so
and I appreciate that, but there's a separate clause, obviously, that talks about the arbitrator's power to interpret the terms of the agreement and any disputes related to, I forget the article section, of maybe 12 or 11, I don't remember. And that's traditionally what we look to see what the scope of the arbitrator's power is. This agreement is a little bit unusual because within Article 3 you have this express limitation, but couldn't you read Article 3 as simply just another article for the arbitrator to interpret? The way he viewed it is, rightly or wrongly, he thought that because these workers that came in on a short-term basis quacked like a duck, walked like a duck, they looked like union workers, that fact violated Article 2 of the agreement that Judge Yoon just talked about. And you may disagree with that. That may be completely wrong, but he was interpreting the agreement, and that's what the district court found, and that's the end of the story.
well, Your Honor, that goes to the merits of the argument, I believe, more than the complete arbitration rule. But with respect to that, and the question of whether the arbitrator exceeded his authority under the CBA, and perhaps they're related questions, but the arbitrator exceeded his authority under the CBA in two fundamental respects. First, in continuing his analysis after he made the finding that no one was laid off or discharged. But secondly, and equally importantly, the arbitrator exceeded the scope of his authority to decide this under the CBA when he ignored the plain meaning of the word assigned in Article 3B. Article 3B gives the company the right to assign or contract work to persons or organizations not represented by the union. And nowhere in the analysis of the arbitrator did he consider whether the CTC employees here were assigned work under the collective bargaining agreement. He analyzed whether they were contract employees, and the arbitrator said they weren't contract employees. But in fact, the company had been arguing all along that these union employees, or that the CTC employees, rather, were assigned work under Article 3B. There's nowhere in the opinion of the arbitrator where he considered that. This is very much like the Clinchfield coal case, where the arbitration provision allowed assignment under circumstances where I believe they were coal lands that were assigned. The arbitrator only considered coal mining operations, and the court reversed the decision because, in fact, the arbitrator clearly ignored in his arbitration decision a key term. That's the same thing that happened here with regard to the word assignment. There was no consideration by the arbitrator of whether the company assigned work under Article 3B as opposed to contracted the work out under Article 3B. This is something that's important because it's just like the RSO employees that the company has assigned work to before. And it's in the brief.
But that was something that was expressly negotiated as part of the agreement, right?
No, Your Honor, it was not negotiated as part of the agreement. The arbitrator said something it says that there was a consent. There's no consent to it. It's not in the arbitration agreement, and that's important too because the arbitration agreement does have a zipper clause. The arbitration Article 13 has a zipper or integration clause that means that this is the only agreement. Also, the Article 10 has two separate provisions that say the arbitrator cannot enlarge or contract the terms of the CBA. But the RSO workers, and this is on page 17 of the reply brief, there's a little chart that shows exactly how the RSO workers are analogous to the CTC employees. First, they're in both instances, they're employees of different AEP utility companies. So the RSO workers are employees of a different utility. The CTC workers were employees of a different utility as well, the CTC plant. And this all happened, this all came about because there was a fire at the CTC plant, or CCT plant, and at the same time, the Mitchell plant needed additional workers. And so there's a memorandum of understanding. It's in the, at least portions of it are quoted in the arbitrator provision, and those portions make it clear that these were CTC employees, not Wheeling Power Mitchell plant employees. In both cases, the RSO employees were not represented by the union, Local 492. The CTC employees were not represented by the union, Local 492.
Can I ask a question about Article 2 and any limitations that the employer has with respect to honoring that article that identifies the union as the exclusive bargaining representative for the plant? So we have that clause in the agreement, right?
Your Honor, that clause is limited because Article 2 begins by saying employees of the company. And In fact, the company is defined in the Article 2, Section 1, as Wheeling, in this instance, Wheeling Power. Prior to that, there was a different entity, I think Kentucky Power. But if you look at Section 1 of Article 2, it's limited to employees of the company. And it's Wheeling Power's position in this case that the CCT employees were not employees of Wheeling Power. And you've got to look to that definition.
That's fair enough. I actually was going to ask a different question. So could the employer hire employees of an entirely different union? I'm not sure how the mechanics of this would work, and make explicit the fact that this union who was coming in to fill new jobs was not the exclusive bargaining representative for the employees at the plant, but still was being allowed to bring on employees under Article 3. And so the current employees are not losing their jobs, no one's being laid off, you're just adding additional employees who are members of a different union. Is that a problem? Could that happen?
Your Honor, it is not, Article 3 is not limited in terms of whether someone's an employee, not an employee. It's in terms of persons, and it's very broad. And it does say that you can bring in, here we go. The company shall have the right to assign or contract work to persons or organizations.
So the answer is yes, you could do that?
The answer would seem to be yes, as so long as no one was laid off or discharged under those circumstances. It's a very broad, very strong rights of management position.
I guess
but
your response to the union's complaints is that they negotiated this agreement and negotiated this limitation.
Well, yes, Your Honor, it's a very strong management rights provision that is not limited. It's they can assign or contract work to persons or organizations not represented by the union, so long as no one is discharged or laid off. Now, that's the circumstance here, of course, is not the circumstance that Your Honor has
So, Ms.
just
Smith,
come up
your
with.
position is this matter shouldn't have gone to arbitration at all.
Your Honor,
As I understand your answer to the Chief's question.
I mean, it's the union's prerogative to bring an arbitration proceeding, but I think that under the
Let's
circumstances.
put it this way. You said that the only question was someone fired? Who posed that as the sole question to the arbitrator?
Your Honor, it's in the CBA, and it's not simply fired, it's when
Or lost their
article,
job?
it's laid off or
Oh,
discharged.
okay, but who,
And if
and
that is the sole
was the
question.
arbitrator told that's the only thing he or she could do?
Your Honor, the arbitrator recognized Article 3B was the provision that the company was invoking under this, and it did,
Yeah,
the
but
arbitrator.
that was you invoked the management rights clause, right?
Correct,
But the union invoked the recognition clause.
correct,
Well, then, they're both clauses that are in the CBA, correct?
correct.
But therefore, the arbitrator, wouldn't he or she have the authority to look at both clauses to balance both the facts and to adjudicate and make it a decision?
Your
Yes.
Honor, the arbitrator recognized that the specific provision in Article 3B would control if it applied under the circumstances. And the arbitrator did make the determination that no one was laid off or
So the
discharged.
arbitrator got it wrong, right?
The arbitrator exceeded the scope of his authority when he went beyond the finding that no one was laid off or discharged in the application of Rule or Article
It
3B.
seems like
Yes.
you disagree with it.
Well, Your Honor, it's more than simply a disagreement. It's that he exceeded the scope given to him under the collective bargaining agreement.
All right.
Thank you, Your Honor.
Thank you very much. Mr. Mr. Dahl?
Good morning, Your Honors. My name is John Dahl. I'm here on behalf of Local 492 and the bargaining unit members that union represents. Obviously, we have a completely different view of this case, and I'll explain to you why. First of all, in response to Judge Gregory's question, this matter came to arbitration because a grievance was filed, and a grievance referenced Article 2 and other articles that would apply. So it came to an arbitrator as a result of a grievance alleging a violation of a specific provision and any other provisions that may apply to the case. The employer raised the issue that 3B and other articles were applicable in some effect, but mostly because of Article 3B. The employer has taken the position that in 3B, once this action occurs where they contract with someone else, supposedly, that all you have to do is decide whether or not anyone was laid off or fired, and that ends the case. It's much broader than that. The arbitrator, as Judge Gregory's indicated, had two competing provisions to deal with, Article 2, Article 3A and 3B, but primarily Article 3B. So in his situation, he was looking at all the evidence. Now,
Mr. Dahl, I'm sorry to interrupt, but so I think I would agree with you if Article 3B simply had the first two sentences of that section, you know, the company shall have the right to assign a contract work, and then this right is limited only to the extent that no one gets laid off. If that was the only thing in the agreement and the arbitrator had decided, you know, that right has to be analyzed against the article that identifies the union as a sole bargaining representative, and he decided, as apparently he decided here, that what in fact was happening is that the union's rights were being impaired, right or wrong, that's the arbitrator's call, and I would likely agree with Judge Bailey that we are not in a position to question that. But you've got this third sentence that really has to mean something, right? That the sole question for the arbitrator is whether the company has violated the foregoing limitation. What do you think that means?
well, if in fact the first sentence, or first part of that applies, then you'd have to go ahead and say, was there a layoff or a discharge? What he determined was that the first part of that did not apply. The company, in its opening statement, argued that this is a contracting out provision. In fact, in his brief, the employer's brief to the arbitrator, referred to 3B as nothing more than a standard, commonly known as contracting out provision. So then the arbitrator looked at that provision and how it was presented at the arbitration hearing as a contracting out. He was asked by the counsel for the union at the case, where is the contract? What contract did you enter into with the CCT group, separate entities owned by the same company? Where is the contract that exists in here? And there was no contract, different from what the RSOs, where they had a separate collective bargaining agreement, and there's a long history of how that occurred.
Yeah, that's a great analysis as to the first sentence, the right to contract or assign. But the sole question for the arbitrator pursuant to this agreement, this clause, is whether the company has violated the foregoing limitation, that is the limitation on laying off or discharging people. And what was did the arbitrator answer that question?
The arbitrator said that that provision above that didn't apply, so you never get to the sole question about whether there's a layoff. The arbitrator determines...
But there's nothing in there that says that you look to the first sentence. It just says, in the event of arbitration over the company's exercise of the rights set forth herein, the sole question is whether there's been a violation of the limitation being whether or not anybody's been laid off.
But the exercise that right means a right to contract. The arbitrator found there was no contract, so there wasn't a right to contract unless there's a contract. He determined there was no contracting out as the employer identified what that language meant. Now, in their brief and today, they argue where the arbitrator didn't deal with the word assign. At no point in time during the opening statement, during the hearing, or in the brief, did the employer ever take the position that the arbitrator should have considered the word assigned being differently from contracting out? The employer, in its post-hearing brief, said that whole provision commonly referred to or commonly known as a contracting out. It didn't differentiate that, didn't put on any evidence about the word assigned, didn't deal with that issue at all. So they dealt with the whole thing as a contracting out provision, and there was no contract. There was no contract at all between the CCT and the or the Wheeling Power Company. There was no contract, so how could there be contracting out without a contract? All the other subcontractors in there, they had a specific collective bargaining agreement or a specific contract with the employer. It had a scope of work to it. It had a period of time it was going to be. None of that happened and when they brought the CCT employees over to work at the Wheeling Power Plant. So the arbitrator, with the evidence he had beforehand, said, it's not a contracting out situation. So if it's not a contracting out situation, then the other provision, the only thing he had sole question is whether or not people were laid off, is not applicable. He interpreted the collective bargaining agreement, looked at the entire agreement and not just a portion of the agreement, and thoroughly and carefully analyzed all of those provisions, including the provision in Article 10, which is the grievance procedure, and Article 13, which is what some commonly call a zipper clause.
Can I ask a procedural question? So you make a good point about the first clause being sort of being conditional to the company's exercise of the rights set forth herein. So is there something in the record that says the company hereby exercises its right under Article 3 to contract or bring these workers in? Is there something in writing about that?
There is not. That's one of the issues that came up early on in the process, is that the union had no idea this was going to happen until they were told late in the process, right before those employees came over, by the way, here we're going to do something. They had no prior discussions with them. They didn't try to get some kind of an agreement how it could work out. As you pointed out, there was agreements for those subcontractors to come in with the RSOs. That's been done for a number of years. Used to be all of those employees were full-time employees of the electric company. They realized that they didn't have that much work for them to do at one particular plant, so they developed these new companies and had those employees go to work for them, and they could go to multiple plants to do mostly outages. And so they come in here and they do the outages and they go somewhere else. But there's a contract for that, there's a scope of work for that, there's a time period for that. This had none of those things, and that's why the arbitrator, we think rightfully, decided that, look, there's not a contract here that could be considered, quote-unquote, contracting out.
But
And
did
for that
the arbitrator consider the meaning of the word assign at that point? If there was no contract, could he not have interpreted the word assign to mean that you could bring in other employees?
I'm sorry.
Sorry. Go ahead.
At no time did the employer ever take the position during the arbitration hearing or even before the arbitration hearing when they got their response, which is part of the record. At no time did they say, well, even if it's not contracting out, it's an assignment we could have the right to make. At no time did they present that to the arbitrator to present it to the union. The only thing they referred that provision to in 3B was a contracting out provision. That is, the entire provision of that, assign and contract out, was only referred to. The arbitrator shall not have to guess or speculate if they are trying to treat assign differently from the contracting out if he's not told that, or not given information about that, or not put on evidence about that. That was not done at the arbitration hearing. That's part of the record as well. So we believe that the arbitrator properly went through the collective bargaining agreement, examined all the provisions that both parties asked him to, interpreted them. Certainly under the scope of a review of arbitration decisions, he was arguably interpreting and applying the collective bargaining agreement. So we believe his decision should have been upheld. The Judge Bailey agreed with that, and that's how we eventually got here. Now, on the other issue that's before the court, on the complete agreement, in our supplemental brief on that issue, we essentially say that this case is not much different from Peabody. And Peabody's a little bit different, but it's not much different. We have just a different take on it, though. We believe if the court would decide, when it brought it up sui sponte, to apply that provision in this particular, or that rule in this particular situation, if you want to save judicial economy, what you would do is affirm the decision of the district court, remand it back to the district court with instructions have the arbitrator get involved and make a decision on what the remedy should be. That way you don't want to have two bites at the apple in regard to the initial decision whether the arbitration decision ought to be upheld. The only issue the court, if it were to go to them, would have to deal with would be the remedy issue. So we believe that would be a better, first of all, ignore the complete agreement rule, or decision rule, complete agreement, and say, no, you go ahead and decide on the merits, which we're okay with that because we think we're good on the merits. Or they want you to have you overrule the decision and send it back to the arbitrator or to the district court for instructions to do the whole thing over again. We think that's not a good judicial use of time, nor is it in the best interest of either one of the parties.
All right.
Thank you.
Thank you, Mr. Dahl.
Your Honors, may it please the court. First point I'd like to make on rebuttal is that, in fact, the arbitrator did understand that the company's issue before it was whether there had been an assignment. In discussing the management's position in the arbitrator's award, and the position of management begins on page 259, goes on to page 260. But on the top of page 260, it's very clear. The arbitrator says it points to the zipper clause in Article 13, that's management company, and argues that since the collective bargaining agreement provides for the right to contract work, the grievance should be denied. It reasons that any claims must be based on contractual provisions restricting management's rights to make work assignments to persons not represented by the union. The only restriction is that the assignment must not result in layoffs. Further applies the zipper clause. And then it goes on to say the employer observes management was already considering the use of outside contractors for anticipated increased coal deliveries when the fire at CCT occurred, notes that there are contractor employees working at the Mitchell plant every day, as well as the RSO employees who routinely work at the plant. The RSO employees are assigned employees. There's no question that they were not contract employees, they were assigned employees, just like the CCT employees were assigned.
So with respect to the third sentence in Article 3 that begins, in the event of arbitration over the company's exercise of the rights set forth herein, you pointed to the section where the arbitrator, in your mind, clearly acknowledged that that was what the management was intending to exercise. But I understand Mr. Dahl's position to be that the arbitrator was entitled to interpret that clause and decide for himself whether or not that exercise was pursuant to the contract. Maybe he got it completely wrong, but isn't that still about contract interpretation and the arbitrator's wide discretion to decide the issue and our limited discretion to overturn that decision?
Your Honor, under Clinchfield Coal, when the arbitrator ignores provisions such as the word assignment, just as the arbitrator in Clinchfield Coal ignored mining operations versus mining lands, that is not just an interpretation of the CBA, it's exceeding the scope of the CBA by ignoring whole provisions. And so, Your Honor, in that instance...
But he didn't ignore it. What you read, he talked about it. The question, you didn't have a contract, and therefore it's broader than... You're taking a position that because that's your position, that cabins the whole arbitration. It doesn't. You look at the whole context of it. You didn't answer. Did you have a contract? It was asked for. Was counsel mistaken or misinformed, Mr. Dahl, in that?
Your Honor, no, there was no contract because it wasn't the term contract under the Article 3B of the CBA was not what was being invoked. It was an assignment. There was no contract with the RSO employees either. It was an assignment. It was an assignment from CCT to Wheeling Power, and it was an assignment of the work by Wheeling
But
Power.
you took it that it started with, is there a contract? If it's not, then you don't get to the question. The assignment occurs within the right?
In the sense of a CBA being the contract, there was a contract.
Oh, yeah, we talked about that. I'm talking
Yeah.
about the workers.
In the
Understand.
sense of there being contract,
Was Mr. Dahl wrong when he said there was no contract in terms of these employees? You heard the argument, didn't you? Was he
yes,
wrong
Your-
about that?
he was not wrong about that. It wasn't the issue, because the
Wasn't
issue.
your issue. You don't get determined just because it's your position.
Well,
It's
Your
rather
Honor.
an imperial view of it, isn't it?
Your Honor, it says assigned or contract. And so assigned or contract means that it could be either assigned or contracted. And in this instance, it was work that was
The
assigned.
arbitrator looked at that language and felt that it was infirm. Your position was infirm in that regard. That was wrong, right?
It was more than wrong. It didn't take into account the word assigned.
What do you mean it didn't take into account?
The arbitrator never considered whether the work was assigned versus whether the work was contracted.
So he got it wrong. But he was interpreting the contract contrary to the way you would have, right?
No, Your Honor, because he wasn't looking at the word assigned at all, even though that was management's position and it's a word in the collective bargaining agreement.
Isn't it possible that he was interpreting it and thought that assign and contract meant the same thing?
Your Honor, they considered that I believe in the Clinchfield Cole case and in other cases as well. And the court has held that even though you have broad discretion in interpreting a collective bargaining agreement, if you willfully ignore words that are in the collective bargaining agreement or ignore a phrase like the two phrases mining operations, coal mining operations versus coal lands, that if you ignore the terms, that's not interpreting it differently, that's ignoring the terms of the collective bargaining agreement and exceeding your authority. I see my time is up. Your Honors, the company respectfully requests that the district court decision be reversed and that the arbitration decision be vacated. Thank you, Your Honors.
Thank you, Ms. Smith. I want to thank both counsel for their arguments this morning. We'll come down and greet you and then take a brief recess before moving on to our final two cases.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Be seated, please. The third case is 23-1950, Selective Insurance Company of South Carolina versus Duffy. Mr. Duran.
Yes, sir. Thank you. Mr. Pete Anderson, Ms. Barrow. Ms. Barrow, I don't mind a brief pause to wait for Ms. Barrow if you're.
Sure.
Would prefer.
We'll take a moment. All right.
Thank you, Ms. Barrow. Thank you. May it please the court, my name is Michael Doran. I am the attorney for the appellants Adam and Lydia Duffy. We are here today to decide if $1 million in coverage for a loss that exceeded $1 million is actually $1 million in coverage. The issue has been stated several different ways in the briefs, and for the record, I would ask the court to allow us to rely on our briefing, the opening brief, as well as the reply brief as part of this presentation. And with that initial start, I would tell the court that we're dealing with a case with a fairly complicated history on a fairly simple issue. Mr. Duffy had coverage through Selective Insurance and 3 other insurance companies for a very serious loss that occurred on September 30, 2016. He and his wife were riding on a motorcycle. They were severely injured when another vehicle negligently drove into them, created very catastrophic injuries that resulted in a long period of medical treatment that resulted in a loss determination that ultimately was found to be that Mr. Duffy himself, Adam Duffy, suffered in excess of $1 million worth of compensatory damages that was the responsibility of an underinsured motorist, and that his wife damages exceeded $600,000. The total award they received through an arbitration proceeding that they started against Selective Insurance came to $1,900,000 total for all damages. While the Duffy started civil actions to pursue their compensatory claims, Selective decided to start this federal action seeking a declaration that their $1 million in coverage was not $1 million in coverage. And then we had to resist that case while we were trying to prove exactly how much the Duffys lost, because Selective stubbornly refused to acknowledge how significant their loss was. And even though their loss significantly exceeded the reduced policy limits that Selective argued for and the full policy limits that we argued for, they still insisted they go through that arbitration process and prove an actual number that well exceeded both the stated coverage in the policy and Selective's incorrect reduction of that policy limits. So it's had a long history. It started out in the spring of 2020, just at the start of COVID. We had a federal case started in declaratory action. We moved to dismiss that case on the grounds that it was too early to decide what the coverage was until they admitted how much the damages were. We actually got a federal court order in this case staying this action until that arbitration proceeding was completed. We completed the arbitration proceedings in September of 2021, had the stay lifted in January of 2022, and then had an order lifting the stay in April of 2022, and we filed our answer in this action in June of 2022. After the case was pending for a year with no particular action procedurally, Selective filed a motion for summary judgment against the Duffys, seeking to have the court declare that they were right. They didn't present any evidence other than the pleadings of record. They didn't submit any affidavits. And the Duffys responded also by not submitting any evidence, relying on the pleadings that were submitted. The coverages that we were talking about is it underinsured motorist coverage. Underinsured motorist coverage is simple and nuanced. The simplicity of it is, from the Duffy standpoint, is they're the victims. And to prove their case, to put a prima facie case of recovery, they have to show coverage. Selective admits it in their pleadings. They have to show injury. We proved that with the arbitration case. We have to show that the injury is within the scope of their coverage. Selective admits that in their pleadings. They simply wouldn't pay it. They said that they should get more credit against this coverage than the law would allow. The district court, trial court, ruled that they were allowed to take the credits they were seeking, that we believe contradict both the statutory law and the terms of the policy itself. Now, in terms of the statutory law, 2279.21B4 is a very complicated statutory dictate, but it has one very overriding principle, and that is to compensate innocent victims to the full extent of the law and to the full extent of the policy coverage. The complexity of 2279.21 sub B is hard to describe, but it comes down to the use of a vehicle as to what the coverage limits can be or should be or are required to be. And there's all different levels of that. So there are two stages of confirming what Selective's insurance obligations are under an uninsured motorist policy. Is first, is it a policy that only covers fleet vehicles? If it's not, it's subject to the requirement that it provide underinsured motorist coverage. Second, does the policy cover, is it a fleet policy or is it a policy that covers private passenger motor vehicles? Our contention is and has been that it covers private passenger motor vehicles such that it's subject to the full terms of 2279.21 sub B, but the full terms of that statute prohibit anti-stacking language in policies. And the nuance here is that the law will allow strictly commercial policies for motor vehicles to limit the stacking issue, to limit the extent that one policy is on top of another policy is on top of another
And how do
policy.
you, Mr. Doran, how do you define strictly commercial policies? What?
So the statute tries to deal with that, and they have two classifications. One, if it's a fleet policy, and it tries to be simple. It says, well, a fleet policy is if it has more than four vehicles, motor vehicles. But that statute really isn't very well defined in that sense.
How many vehicles were involved?
But it's our contention there was only the four vehicles, which were the trucks, and the trailers would not count as a vehicle for purposes of underinsured motorist coverage. And that's the nuanced part here.
And what's the basis for that distinction that in the
Because
face
of the
of?
purpose of the statute. So when you look at the statute and all the different regulations that apply to underinsured motorist coverage, they're dealing with passenger vehicles of some kind. And they specifically say and define in a separate statute what a private passenger vehicle is, and that's that chapter 5840-10 and 15. Those are again convoluted statutes as well, and they appear to provide an exemption from the commercial part of it to farmers and agricultural business enterprises.
But within, sorry to interrupt again, but within that definition of private passenger motor vehicle, there's also a separate definition of motor vehicle which talks about self-propelled vehicles and every vehicle designed to run upon the highways which is pulled by a self-propelled vehicle, which would seem to include the trailers that were part of the coverage in this case.
Now, I saw you on a reading, and my belief is that you're reading the definition in 20-4.01, is that correct?
Yes.
Okay. 20-4.01 is the introductory motor vehicle statute definition that's very comprehensive and broad. And that's not the only place that the statute defines in 4.01 what a motor vehicle is. There's actually, if you go down to, and I think that's subpart 23, I'm not sure, I lose track of the numbers.
Right again.
Subpart 27 is passenger motor vehicles. And that statute defines passenger motor vehicles, and it's motorcycles, it's all different kinds of vehicles, including some commercial vehicles. And then they even have a private passenger motor vehicle definition in subpart 27 of that same statute. And you know what it says? Anything we didn't say before. All these vehicles, and it gets to private passenger motor vehicles, says anything that wasn't already identified. But in chapter 58, they go through a very specific, elongated description of what a private passenger motor vehicle is. So they're using a different definition of private passenger motor vehicle in the insurance statute than they do in the regulatory statute at the beginning of chapter 20.
Can we back up, thank you for that. Can we back up a little bit to this policy itself?
Right?
Selective policy, was that a commercial policy, a business?
Yes, it's business
Okay.
policy.
But you're saying that it doesn't need to be exclusive, it could also include vehicles that are used simply for personal purposes, non-business purposes?
Yes, Your Honor. Because in a lot of these cases that we deal with from the appellate level have these business policies where we're applying it to personal vehicles. And in this case specifically, we have two specific nuances, again, with what the individual private coverage is. Mr. Duffy was an individual named insured at the start of the policy. And then they added another endorsement that says it's individual named insured, and that's at the appendix, joint appendix, page 186. And you know, it's a very convoluted policy. It's over 250 pages. This one-page endorsement made Lydia Duffy a named insured. It said personal auto coverage, if any auto you own of the private passenger type is covered auto under liability coverage. Well, that's that symbol 7, the covered auto, it's a list of the 7 pieces of equipment that are defined in that premium page. And it says the following is added to who is an insured. Family members are, and members are insurable for any covered auto you own of the private passenger type. So this policy specifically changed and added more insureds for use of a private passenger vehicle insured by this policy. So it contemplated having a vehicle listed on that policy that was a private passenger vehicle. So that's, even though it's a business policy, which happens. So that's why we contend.
Is that a rider?
Excuse me?
Is that in a rider provision? Is that what you read from?
It's part of the policy, and it's called an endorsement.
It's endorsement. Okay.
Yes, sir.
All right.
And it says, this endorsement modifies insurance provided under the following and includes business auto coverage form. So it has quite a few modifications to it, and that's why it's a very complicated policy. But what we're contending is that in chapter 58, 40, 10, and 15, even though they only reference motor vehicle generically without any real description of it, on the fleet part of it, we contend that because it deals with underinsured motorist coverage, they're talking about passenger vehicles, not trailers. And trailers don't count on the fleet designation. And we don't have a case that specifically deals with that. That Nationwide versus Mabe case back in '96 came very close. It was an interesting case because it was a Nationwide wanting Farm Bureau to add to the pot, and Farm Bureau had a policy that had 2 vehicles designated on it. One was a trailer and one was a Mack truck. And at that time in '96, they were still dealing with intra-policy stacking within one coverage form, and then intra-policy stacking between 2 coverage forms. And the court just blew out the intra-policy stacking and says, well, it's a trailer, so that's not covered. And then they went on to the Mack truck part and said, well, that's a commercial vehicle, so it's not a private passenger motor vehicle. So we don't have inter-policy stacking either. So that Nationwide versus Mabe case is instructive and helpful, but it doesn't really quite answer this question directly on point. And what all the cases have done is they have all said, let's look at the intent of the statute and interpret it that way. And that's why we have that McCaskill case that says, well, they said 4, but 5, what's the difference? Well, it's the exact number. Yet the courts decide that if it doesn't really fit the framework of the statute and the intent of the statute, we're going to look past some of those nuances and find coverage. And so that's why we contend this is not a fleet policy. There's nothing in that policy anywhere it says fleet. They didn't even charge premiums for the trailers under the underinsured motorist coverage. There was no circumstances where a trailer by itself, using a trailer by itself without a passenger vehicle, is going to have a UIM circumstance. You're not going to crash a trailer. And that's why there's no coverage for it. That's why they don't charge premiums for it. Because you don't have underinsured motorist coverage on a trailer, so it won't count towards the fleet number in the underinsured motorist fleet designation. And that's a significant point.
So Dorn, do you have a case that supports the proposition you stated earlier that when you're dealing with a policy which on its face is a business policy, includes a number of vehicles, that if the vehicles are being used both for personal and business purposes, that the stacking law would invalidate any set-off clause in those policies?
I'm not sure I understand the question entirely, but I know there's business policy cases where the court has found it's subject to the anti-stacking provisions because it either was non-fleet or because it involved a private passenger motor vehicle.
Okay, I think that was what I was asking.
Right, and so the case, like the Farm Bureau Dana case deals with the different policies, and that was a recent case where the court kind of undid I'm over my time, may I finish the question? The Farm Bureau versus Dana case actually undid the Farm Bureau versus Gurley case that was decided years earlier, where they were going through the dichotomy between per person and per accident coverage, and when it's per accident coverage settled on the liability side, we'll do per accident UIM coverage. That's what Gurley said. And then in Dana recently, they're saying, don't get tied up in all the words. Just go with the overall philosophy of the statute, apply to the particular facts you have before you, and then deal with the coverage in that way. So that's what the court has consistently done with all these cases. They all intermittently deal with both business auto forms and personal auto forms. The business auto forms are the ones most litigated, and most of them are the Farm Bureau cases with the agricultural side of their business. So a lot of the Farm Bureau cases are business policy forms.
All right, thank you, Mr. Dorn.
Thank you.
Ms. Barano?
Thank you, Your Honor, and may it please the court. Caroline Barano for Selective Insurance Company. I'm going to be handling or splitting the argument with my co-counsel, and I'm going to be trying to focus on the issue of whether the inter-policy stacking provision applies here and why, and whether or not there was sufficient evidence, factual evidence in the record at summary judgment to make the determination as to whether or not the vehicles under the policy classify as private passenger vehicles. Defendants argue that they should be able to use the inter-policy stacking provision under the FRA such that they could get the full $1 million policy, and that to do otherwise or to allow otherwise is to reduce UIM coverage available under the selective policy. That is not the case. The FRA allows inter-policy stacking of UIM policies only under certain circumstances, the circumstances that he mentioned that are enumerated in the actual FRA itself. And the policy there, or the provisions of the FRA, do not apply here. And that is for two reasons. The primary reason is that the policy is not a non-fleet policy. There is various case law that essentially interprets that provision of the FRA, the question that is presented under that provision, as being twofold.
I'm sorry, what provision are you?
I am talking about the provision in the FRA under section 20-279.21 and so that's the language that says that provided that this sentence shall apply only to insurance on non-fleet passenger motor vehicles as described elsewhere in other statutes. And basically, the case law has interpreted this language as allowing for inter-policy stacking if the policy provides non-fleet coverage and the policy is of a private passenger type. And here, based on the actual language of the policy and the type of the policy, it is clear that this policy is not non-fleet or is a fleet policy, such that the exemption here applies and the FRA provision that allows for inter-policy stacking does not apply here.
Before you get too deep into that, do you agree that the nature of the policy by itself doesn't answer the question? So I understood that this was a business auto insurance policy, right? Whatever that means. But that by itself doesn't mean that the Williams in this case, or the Duffys, I guess, wouldn't be entitled to coverage?
I would actually not agree with that, Your Honor. And the reason for that is, Aetna v. Fields. Under Aetna v. Fields, the court found that a business auto insurance policy, by the fact that it was a business auto policy alone, was sufficient to show that it was a fleet policy. Now, I know that counsel for defendants mentioned that there are exceptions to that, and I agree. One of the exceptions is enumerated under, or was based on a holding in McCaskill, which I know that counsel for the defendants mentioned. And why McCaskill doesn't apply here and why it is kind of an outlier is because the McCaskill examines intra-policy stacking, which is now illegal under North Carolina law. And why that is relevant, even though Aetna also addresses intra-policy stacking, is that McCaskill relies on the fact that intra-policy stacking is at issue to determine that 5 vehicles there is not non-fleet, is non-fleet and is not fleet, because since there were only 5 vehicles, that allowing it to be non-fleet would not hurt the underlying reasoning for the statute, which was to protect against allowing a claimant a windfall that they did not bargain for. And that policy in McCaskill was actually a personal auto policy, which is not the case in Aetna and is not the case here. So the selective policy here is actually a business auto policy. So that is the distinguishing factor there.
So if I'm understanding your position, we could just stop there?
Sorry, say that again.
We could just stop there and say this is a business policy. The statute was not intended to deal with a business policy. End of story.
Well, certainly, that is what we would contend, is that you have to have the provision of the interstacking policy provision of the FRA applied to the policy. The policy has to be non-fleet, and it has to cover private passenger vehicles. And because the policy here is not non-fleet or fleet, it does not apply, meaning that the FRA provision at issue does not apply to the policy, and the policy language is what rules here. So yes, Your Honor, we could just stop right there. However, to address the arguments, the other arguments of defendants, which was an argument that there was not sufficient evidence on the record to classify the vehicles under the policy as a private passenger vehicle or as non-fleet private passenger vehicles. That's simply not the case. The case law shows that you can rely on the actual terminology of the policy. The policy at issue here was attached as a part of the complaint and by defendant's own admission became part of the record. And so the court properly relied on that when making their determination as to whether or not vehicles under the policy were non-fleet private passenger motor vehicles such that the interstacking policy provision did not apply. So we agree, or we believe that there was sufficient evidence in the record, but also this is on appeal the first time that defendants have raised this argument, and so we also object to the argument on that basis. And going back into that, it says that the record showed that the vehicles were covered by a business automobile coverage insurance policy, which even if the policy language enough under the declarations that discusses the different types of policies, different types of vehicles listed were business vehicles, because one thing that counsel for defendants mentioned was that this was an individual policy, or a policy that was issued for an individual. This was not a policy that was issued for an individual. It was a policy that was issued for Mr. Duffy doing business as Corrective Landscape Services, which would be issued as, or issued to a sole proprietorship. So it was a policy, even from the beginning, whether or not lawn care, et cetera, was added as another insured later on. It was from the beginning a business auto policy, and the policy itself can stand for the proposition that the policy itself can stand for the proposition that the business, that the vehicles listed were being used for a business purpose, excuse me.
What about, does it make any difference that the endorsement included Mrs. Duffy?
Sir, can you say that
The
again?
endorsement, that she was on the endorsement, that she was included as a covered person, that counsel mentioned, does that make a difference?
Your Honor, I do not believe that makes a difference. There is an endorsement that discusses who is considered insured under the policy, and that particular endorsement that he is referencing, or that counsel for defendants is referencing, is an endorsement that states that the named insured is covered under the policy, and then any family members of the named insured. Obviously that is something.
So, and does that person have to be doing something in a commercial nature to be covered?
That person does not need to be doing
So
something.
it's a
in the commercial.
hybrid, it's somewhat of a hybrid type of insurance policy, isn't it?
Well, actually, what I would say, Your Honor, is that particular endorsement is more of a carve-out in the fact that it is showing that there is policy for a family member like Miss Lydia Duffy, and it is an exception to the business coverage in the sense that this particular coverage is provided under the policy whether the vehicle being used at the time of the accident.
So it's broader than a commercial policy, isn't it?
Well, I think that
You did it by, you collected the premiums you got paid, it wasn't free when you added her to that, right?
that, well, actually, Your Honor, that particular endorsement wasn't any additional premium.
Is that in the record?
That is in the record,
That
Your
you-
Honor.
That it was free? That's in the record?
Well, the record has a copy of the policy in it, and in the policy, it shows that the premiums are assigned to the actual vehicles. The vehicle that was involved in this accident
Mine
wasn't one.
says that too, but, my family member's on that, I'm paying the premium.
Right, so yes, Your Honor, the way that they assign premiums here is based on certain vehicles under the policy and the nature of certain
Isn't it
vehicles.
counterintuitive, you said you're gonna give $1 million coverage for uninsured motorists. Then you only give up $300,000, and they have $1.9 million in certified undisputed damages. It's something a little counterintuitive, isn't it?
Well, Your Honor, it certainly may appear that way at first, but
Certainly does.
well, the reason that it actually doesn't apply that way is because there were actually three other at issue. There are actually three other policies that are at issue that the defendants made claims under for UIM
I know,
coverage.
I got the math.
And due to the FRA and the public policy, the reason for the FRA and its implementation was to put the defendants back, or the claimants back into the place that they would have been had the tortfeasor been adequately insured. And so here, and based on the provisions in the actual policy and policy language, it basically lays out that the maximum amount of policy coverage available is that is the most amount of coverage under any policy. But that language does not necessarily mean that policy, that the amounts the coverage limits are in addition to what has already been paid out. That would cause a windfall for the benefit of the defendants and would go beyond the public policy of the statute because it would provide them with more limits than they actually bargained for when they bargained for each of the 4 policies that they made claims under here.
Can I ask you about this number, the number of vehicles that seems to be relevant for deciding whether or not a policy is fleet or non-fleet? So if the Duffys had simply owned 2 vehicles under this selective insurance policy, even if they used the vehicles in their business full-time or part-time, do you agree that that would not be a fleet policy?
I do agree that that would not be a fleet policy
Okay.
because I believe at that circumstance, it would, the actual language of the definition of non-fleet motor vehicle would be controlling.
So Mr. Dolan says that in this case, that applies because these trailers are not vehicles.
Right, so the trailers are vehicles under the statute, and there are cases that have interpreted that. But under the provisions of, and I apologize, I know I've gone over my time. Oh, sorry, Your Honor, it is the provisions of Section 20 -4.01, subsection 23 of the North Carolina General Statutes that indicates that a motor vehicle under North Carolina statutory law includes a vehicle which is self-propelled and every vehicle designed to run upon highways which are pulled by a self-propelled vehicle, and that has been interpreted to be a trailer because trailers are being pulled by self-propelled vehicles such as a pickup truck or things of that nature.
All right, thank you very much.
Thank you.
Mr. Peterson?
Good morning, Your Honors. May it please the Court, Daniel Peterson for Selective. And the part that I'm going to kind of talk about in two parts here is that, one, there was mention of it in the appellant's argument and certainly coverage of it in its brief, talking about whether Selective fulfilled its obligations, and I know Judge Gregory voiced some concerns about that with my co-counsel. And then I'm also going to discuss something that was briefed in the appellant's brief about the severability of insured's provision, and certainly we'll be glad to take any of the Court's questions on anything else related to our briefing and our position, regardless of whether I'm discussing it or not. Selective tendered $300,000 to the Duffys after the arbitral award, and that was based off of an offset from the other uninsured motorist coverages that were available to the Duffys. The relevant provision being in the Selective policy at Joint Appendix 152, where it states the maximum recovery under all coverage forms or policies combined may equal but not exceed the highest applicable limit for any one vehicle under coverage form or policy providing coverage on either a primary or excess basis. That highest applicable limit is a selective limit of $1 million. And thus, the Duffys having received, and as was admitted in their answer in this matter, that they received $700,000 in uninsured motorist coverage in addition to the tortfeasor's liability coverage, which was not sufficient to cover their injuries, which was not taken as an offset by Selective. But they received the $700,000, and that's where the tender for $300,000 came to get them to the maximum limit applied in the policy. The district court got it right here by applying the Height case, and that is discussed in both briefs and in the district court's order. And they're very similar.
What about the fact that he cites to the Dana case?
Yes, Your Honor.
Can you talk about how, and I don't think this was mentioned in your brief. So what is your argument there under the Dana case, whether that case actually supports a per-person application to the limit?
Well, in the Dana case, Your Honor, the fact that there was a per-person limit, and in the Height case, there is no, the policy under the Height case, there was no per-person limit, and in our selective policy, there is no per-person limit. So that's the distinguishing factor. Where there is a per-person limit, the Dana analysis, the per-person limit comes into effect. And in fact, it's kind of no individual will go over the per-person limit. It doesn't stand for the proposition that this adds multiples to the coverage. So it doesn't convert the per-accident coverage of the 1 million per accident coverage that exists in both the selective case and then the $500,000 per accident coverage in the Height case. It does not convert that to individual per-person limits. Does that address your question, Judge Yoon?
Did the Dana case include this subsection G that seems to separate insureds individually? Did it address that?
No, Your Honor, it did not, and I'm glad to address severability of insured's concerns. I'm sorry, Your Honor.
No, go
I
ahead,
mean-
because I think that's, their point is that that clause seems to suggest that you take each insured individually and apply the set-off clause to each of them.
Well, in all the case law that applies those severability of insurance provisions, which as Your Honors are aware are common in these types of policies.
They may be common to you, but not to us.
Well,
Thankfully.
frankly not to me either. But and to the extent of our clients, the severability of insurance provision is under the case law applied to require insurers to look at each individual when applying exclusions, such that if there is intentional conduct on the part of an insured that excludes them from coverage, the insurer cannot say, all of you that were in the car accident are out. Just that insured. That's the kind of provisions that, such as discussed in our brief in the Penske case from the Eastern District of North Carolina, and then looked on favorably in the North Carolina Court of Appeals under Universal Insurance v. Burton Farm. Those are the kinds of applicability of the severability of insureds provision. Moreover, the severability of insureds provision in this policy expressly addresses a carve-out for limits on insurance, which is, again, the $1 million per accident. So there is no case law that stands for the proposition that the severability of insureds clause expands the entitled coverage here to $1 million per insured. And there's nothing in the policy that does the same, Your Honor. In fact, it expressly limits it, carves out the limits of insurance for this very purpose. So we think that reading the policy on the whole, that would, applying the severability of insureds provision would, one, defeat the purpose of the uninsured motorist coverage, which is not only to make the insured whole, but really just to put them in the same place they would have been had the tortfeasor been adequately insured, which they were not here. And so that is kind of the distinguishing factor on the Dana case and the severability of insureds provision. Returning to the Height case, in Height there is a $500,000 per accident limit. In the selective policy there's a $1 million combined limit. And in Height, the trial court made the kind of determination that the Duffys seek here, but was reversed by the North Carolina Court of Appeals. And it is where the Court of Appeals held that two insurers were collectively entitled to that per accident limit, less any appropriate offsets from other insurance proceeds. And so the rationale for the court's holding in Height, and as the district court applied in this case, applies here. The purpose, again, of a UIM policy is to put an injured party harmed by an underinsured tortfeasor back in the same place they would have been. And so in Height, the court concluded that Nationwide owed its insureds collectively $300,000. And on this $500,000 single combined limit, here there was $700,000 in eligible offset payments by the uninsured motorist based on the language of our policy and based on Creed v. Creed 258 NC at 564, which the trial court cited in its order, that we accounted for the uninsured motorist payments from the other insurers, other underinsured motorist coverages. Selective did not take any offset for the primary tortfeasor's coverage because of the specific language in our policy related to changes in conditions and the highest applicable limit that I've already discussed. That's all of the remarks I had prepared, Your Honors. I'm happy to take any questions the court may have.
One question.
Yes, Your Honor.
Was counsel correct when he said that your policy had about 250 pages?
I would believe it, Your Honor. I have no reason to disagree with that.
250 pages for $1 million UIM policy.
I'm sorry, Your Honor. I didn't mean to interrupt you. I'm sorry.
I thought you were about to. Okay.
I was going to answer. I thought the question was concluded. That's all. My
Oh,
apologies.
but it took 250 pages to explain what the coverage was.
Not the uninsured motorist part, Your Honor, the underinsured motorist part, Your Honor. That was, we attached the entire policy, which ranges from liability policy to various, again, business coverages that Corrective Landscape Services, which is Adam Duffy's sole proprietorship business, needed. It is not just the underinsured motorist coverage that's 250 pages, thankfully, for my sake. That's a much smaller portion of the total policy. We did feel it appropriate, so it was all before the court to put it in the record.
Right. So I take it in that 250 pages somewhere it tells them, somewhere in there, that, listen, it says $1 million UIM policy, but you're not going to get that unless nobody has any insurance.
Yes, Your Honor, we would consent.
You tell them that, right? Say, if the only way you're going to get $1 million is that no one has insurance, and then you have obviously injuries that equal or exceed $1 million. That's in there in plain language somewhere.
There, Your Honor, at Joint Appendix 152, the changes in conditions and other insurance policy provision identifies exactly what Your Honor is talking about, in the sense that where you've got other underinsured motorist coverage available, basically we're going to fill that gap between whatever you get paid by these other insurers to get you to the $1 million. In that sense, it's sort of an excess policy to fill that gap up to the $1 million. So Your Honor is correct. If there was no other underinsured motorist coverage available to the Duffys, there would be $1 million in coverage under this policy. However, under the provision at Joint Appendix 152, that is not the case, Your Honor.
Thank you very much.
Thank you, Your Honor.
Mr. Dorn?
Thank you, Your Honor. I appreciate that. And I want to focus specifically on the Haight decision, H-I-G-H-T. I don't know if that's the right pronunciation, but it's Haight versus Nationwide. Clearly different, clearly illustrates the point why this coverage is here and distinguishable. There was $200,000 worth of liability insurance credit. And the interesting part about that case is the liability policy actually paid $270,000 worth of payouts, and there was an unfinished claim that had another $25,000 left on that policy, and perhaps those people withdrew that claim just so the whole $300,000 wouldn't be used, and so Nationwide wouldn't get the $300,000 credit. I'm not sure. But there the court only applied $200,000 liability payments against the $500,000 UIM coverage, which is what UIM is supposed to be. It's supposed to be an envelope around the liability coverage so that whatever liability fills up, UIM covers the rest. And so that case is consistent with that analysis. But when you apply the math to what Mr. Peterson just said and call what we got a windfall by counting UIM coverage for two separate individuals on top of each other is mind-boggling. When you look at the analysis, if, for example, if Ms. Duffy withdrew her claim altogether, their position is that Mr. Duffy gets $650,000 because he only had $350,000 of UIM coverage. Ms. Duffy's not making a claim under the policy. She withdrew her claim. So now their coverage increases by $350,000. So that's the absurdity of their position. They're talking out of both sides of their mouth. They're saying, oh, over here on the other insurance coverage, we get to consider all claimants at the same time against the policy limits that says this is our policy limits cap for everybody, all claims, no matter what, no matter how many cars, the top limit. Well, the top limit was supposed to be $1 million. But because they double up on what they're trying to collect on other insurance, a separate coverage altogether, and putting two claimants in that, their coverage goes from $1 million to $650,000 or $750,000, depending on how you deal with that extra $100,000 on liability. So we have a contradiction in how they're interpreting their policy, and it's inconsistent, and it actually violates the, quote, separability clause. I never knew there was such a thing, but in the conditions part, it says you're going to consider each claimant separately. Now, the cases get litigated over liability claims. Now, when you look at this policy, this subpart G in conditions is in the business auto form. The business auto form actually does not even talk about underinsured motorists at all. Doesn't talk about uninsured motorists at all. The endorsements for the underinsured motorist coverage is the only place we have the coverage added. And there, when they talked about limits, it's a separate paragraph. It says, limits are $1 million. We don't care how many claimants, how many cars, how many policies. You take the top policy, that's the most anyone gets. Then we go over here, other insurance, in conditions, just like in claimants, in conditions. Conditions are, so when you look at that clause, it says benefits under the policy or claimed or lawsuits under the policy. So you have two different aspects it's talking about in that subpart G, and those other cases are talking about whether they have to provide counsel for both people that were sued or whether they're considered separate insureds or not. And that's a fairly complicated business question that comes up, and that's what these policies try to deal with. It also applies to the benefit part of the case, and they added a benefit part of the case through the private underinsured motorist coverage. And so that's why we contend that even if the statutory argument does not prevail, under this policy, you look at each claimant separately for purposes of the other insurance clause, because that's exactly what that policy says. And if you read it any other way, then that one subpart D, where it says the insurance limits are $1 million, you just added a clause saying the coverage limits are $1 million no matter how many policies, no matter how many claims, no matter how many insureds, less whatever we decide to take off of it. Or, to be more specific, less any other money that's offset by the underinsurance clause. It doesn't say that there. The underinsurance clause is separate, is read on its own, applied on its own, and different from the limits cap of $1 million. So you do look at these individuals separately. You look at Mr. Duffy, he got $350,000 of UIM coverage from another source. If they get credit for that, by God, they get credit for that. That's down to $650 for him, total allowance. And for Mrs. Duffy, same thing. You take $350 off the $1 million for her. She only has $650 of UIM left. And if the two of them have a claim more than that $650, they get the windfall of not having to pay the full loss. They get the windfall of reducing a $1.9 million claim down to whatever the $1 million is. And that's what happens when the statute's not applied. They get to take away our stacking, but they don't get to take away two claims at the same time through a different clause that doesn't apply under the limits. Now, I am out of time, and I apologize. And I'll answer any questions you might have.
Thank you very much.
Thank you. Just
Absolutely.
one question.
Sure.
Did the Duffys argue before the lower court that there exists a genuine issue of material fact as to the limits of insurance and then the definition of insurance?
We consider all these facts really undisputed, but if you interpret this policy to be where we lose coverage for Mrs. Duffy because she pursued her claim, and you add her UIM benefits to Mr. Duffy's claim, that we consider that a factual determination that the court, or policy interpretation that the court shouldn't have ruled in a summary judgment fashion. And we never really got a chance to address it with the court's feeling on what he decided the ruling would be. Nobody cited the Haight versus Nationwide case, and during that presentation, I specifically told him in my argument, I'm not aware of any case where they counted two beneficiaries against UIM coverage in that situation. And then the Haight case comes up, and they applied the benefits of two beneficiaries, the recoveries of two different insureds under one claim. But that was that $500,000 policy, and that's a little different with the liability issue as well. So the judge found a case that contradicted my argument, but that case is distinguishable, and I never got a chance to address that case in his presence. So some things he did with his order surprised us, and when we look at it and compare it to the record, we believe in that context, like with the Irwin versus Tweed case, nobody in the Tweed case even argued that there was a question of fact. And the court sent it back twice saying, yeah, but there's a question of fact from here, from the bench. That wasn't answered. You got to go back and answer that question of fact, because it's not clear from the record that question of fact was answered. So sometimes that happens, but we believe the facts were clear. It's not a fleet policy. We were clear our damages exceeded $1 million, clear they had $1 million in coverage, and they should pay it. And we felt there's no dispute to that. But when you look at the ruling, some of the things he did just don't jive with the record. There's no facts to support going beyond what each of the parties were arguing the law is. And so that's why we contend that under Tweed, you would send that back if you still felt like there was questions about some of these nuances.
All right.
Thank you, and I apologize for running over.
Thank you. I want to thank counsel for their arguments this morning. We'll come down and greet you and move on to our final case.